Ask Senator Watson, since you're out there talking so much, if you'll please open us up with a word of prayer. What's your mic number?
Lucky number 13.
13, all right.
Thank you, Mr. Chairman. Let's go to prayer. Thank you, Lord, for looking over us, keeping us safe this weekend and in our travels, and continue to put a halo around those here at the Capitol, and let us remember who we represent, our citizens here, and let us do your work in your eyes. In Christ's name I pray. Amen.
Senator Watson. All right, we have three bills on the agenda today. We're going to start with, thank you. We have one guest judge with us today, Judge Lawton Stevens from Western Judicial Circuit. Judge Stevens, thank you for joining us today.
Thank you.
I believe also Judge Paige Whitaker is also here. I think she's here to testify on a bill. Welcome as well. Thank you all for joining us. Always good to have members of our judiciary visit with us down here at the Capitol, or up here at the Capitol. So we'll start with Senate Bill 12, and Senator Alberts is already in place. We are working off a substitute. I have LC 491252S. Is that what you have, Senator Alberts?
That is correct.
All right, the floor is yours. If you'll introduce your guest as well.
Sure will. Thank you, Mr. Chairman.
Let me stop. I'm all out of whack. If you want to be heard on one of these bills, we have sign-up sheets up here now at the front. If you didn't sign up yet, please come up here and we'll get you signed up to be heard on these bills as well. Now the floor is yours.
All right. Am I hot? Okay. Thank you so much. I'm honored to be joined by our very own Fulton County District Attorney, Fawny Willis, and her Executive District Attorney, Mike Carlson. They are familiar faces here at this committee because they were kind enough to work with me on this bill last year and have been instrumental in combating the gang crisis we face here in the state of Georgia. I want you to know that the bill that we're looking at today, Senate Bill 12, is very similar to what we passed out of this committee last year. We just did take two parts of this bill out in order to have three separate bills in order to make them a little more smoothly. One of them already passed our Senate, which was Senate Bill 14, which was the bill where we gave the GBI a concurrent jurisdiction for things related to terrorism. So this, again, is language that has already passed this committee, and I will do a quick introduction. This is in response to our increasing crime, the highest it's been in a generation. Make no mistake, we have a gang crisis throughout our state and throughout our nation. Depending on the reporting agency, it's estimated somewhere between 70 and as high as 90% of all violent crimes are committed by criminal street gangs. I want that to sink in for everybody because sometimes it's underreported that we could think that up to 9 out of every 10 violent crime is convicted by a criminal street gang member. And they go after some of our very most vulnerable citizens. They become the victims of these repeat and violent offenders. This is criminal justice reform, make no mistake. And it's very consistent with what former Governor Deal used to say. We have to separate the people we are afraid of versus the people we are mad at. Folks, this is the people we are afraid of. This has been very well researched, and we involved every major stakeholder. Over the last year and a half, we met with prosecutors, district attorneys, judges, police chiefs, sheriffs, the GBI, Georgia State Patrol, FOP, bondsmen, police foundations, pardons and paroles, corrections, community supervisions, victim rights and activist groups, the Georgia Trial Lawyers Association, just to name a few. Very proud of the great work by our very own Governor Kemp and now Governor Burt Jones, who have also supported anti-gang legislation, knowing again that this is our single biggest threat to society currently. We have to continue to reform the system in order to make it work better and give the tools we need to our law enforcement no matter where they are. There is a very real and very need for this to happen. And at this point, I'm going to take you section through section through this bill and then ask District Attorney Willis as well as Executive Director Carlson to make a few comments and then hear from you from your questions that undoubtedly will come. Section 1 is simply the title. This is the Protecting Victims and Dismantling Georgia Street Gangs Act. Section 2 is punishment for the possession of a firearm by a convicted felon or first offender probational in a forcible or domestic violence felony. This is to make sure that people who are consistently doing things wrong and then are doing it with a history of violence and a gun are having a mandatory minimum sentence, moving it from 1 to 10 years to 5 to 10. Section 3 is a legislative declaration on gangs, stating that we acknowledge what this is, what the problem is, and how we're going to address it. Section 4 revises the Gang Act to clarify certain things. Specifically, we are looking at how it's benefiting the community, and how further civil penalties, even when someone may not be convicted of the criminal crimes, that civil penalties can still be taken, action be taken to protect those who have been wronged. Section 5 revised the Gang Act so that certain prior crimes can be used when affiliating people with a gang and certain charges against them. We can't have people coming up who are repeat offenders and not having the information and knowledge to those in the courts for what they have done in the past in order to continue to connect the dots of bad behavior. In Section 6, we revised the Gang Act to expand the venue. Very quickly, gangs will move from city to county across our great state. And we do not want to have that separated in several different jurisdictions and have each one trying to do the job. In order to present RICO charges and other things, we need to make sure that we can pull those venues together and go after the bad actors. In Section 7, it relates to bonds in gang cases and to make sure they are always heard in a superior court. And I'm going to give you an example. In 2010, not so long ago, Superior Court judges who would normally hear bond prosecutions, an 11-year-old child was murdered by a gang member who had been released by a magistrate judge, and that was inappropriate. In Section 8, it's about recidivism punishment for subsequent convictions for acts of elder, disabled adult, and minor abuse. In some of the most heinous of crimes, gang members go after our most vulnerable, our elderly, our disabled population, I call special needs, and our minors. In fact, just today we passed a great bill carried by our very own Senator Bill Hatchett about gangs going after minors and recruiting. In this case, we want to make sure that we increase the penalties and we define what these populations are. In Section 9, this goes back to what's called the equalizing the notice provisions for uncharged misconduct and evidence. This is to make sure that everything is brought out in the beginning, and what doesn't happen is what some like to call trial by ambush. In Section 10, this again allows prior evidence, in this case for elder, disabled, adult, and minor domestic abuse to be brought forward, and it could directly relate to things such as hate crimes, which is a strong position that this Senate body took and the governor signed into law when we said there is no place for hate in our state of Georgia. And last but certainly not least, Section 11 is just the effective dates for some of this bill in order to give time for it to go through the system and make sure that the people who will be handling this will be prepared at the time. Mr. Chairman, in closing, before I turn it over to DA Willis and Executive DA Carlson, I just want to reiterate something. We have a crisis. It's nothing short of a crisis. This is criminal justice reform, and it's time for us to continue our work of acting to making sure people can feel safe in their communities, and we can make sure Georgia stays the number one place, not just to do business, but to live, work, and play. And with that, I'll turn it over to Fulton County DA.
Good afternoon. First of all, I want to thank Senator Alberts for bringing this piece of legislation to you, and of course, thank each of you for your time today. The Fulton County District Attorney's Office, through me and through Executive District Attorney Mike Carlson, we are completely behind this bill. We think it is a bill that we need to help us do our work. When I came to office just a little less than 3 years ago now, there was debate if actually there were gangs in Georgia. People wanted to think that, oh, that's a Chicago problem, that's a New York problem, that's a California problem. It seems though in these 2 years and 2 months, people have come around to really start talking about the issue, because if you don't talk about it, you can't solve the problem. And I don't think I have to convince any of you that we do have a gang problem here in Georgia, and especially in some of our metropolitan areas. We've done a lot through my office to make sure that we are educating our law enforcement partners by giving them classes on things that they should look for for when they're doing investigations. And I can tell you by doing that kind of work, even with our Atlanta Police Department, gang warrants are up 300%. Not because gang crime has increased 300%, but because they're actually now collecting the evidence they need so that we can have good prosecutions. This bill is really important, and it does talk about gangs, but I want you to really focus on some of the people that it helps the most. It helps your constituents that are the victims of domestic violence, which is that ugly little crime that people don't talk about, but is going on in every neighborhood that each of you represent. This bill really addresses issues that impact your domestic violence victims. This bill also addresses what we would call disabled adults, adults that are vulnerable because of their mental capacity or their physical capacity, the very people that you really are elected to protect. And then it protects children and the elderly. Children in instances of abuse. It doesn't deal with sexual abuse because the legislatures have already dealt with that, but it does deal with people that repeatedly abuse children. And so if you really think about what the purpose of the bill is, it will make the bill make sense, and I don't see how it's anything that anyone could not support, because all of us took an oath and we swore to protect those that are the least among us, and that is really who this bill goes to. So just very briefly, I want to go through some of the sections. Section 2, which is punishment for possession of a firearm by a convicted felon or a first offender probationer in a forcible or DV felony for a following felony involving domestic violence. What I want you to keep in mind is that when there is a handgun present, and you'll hear from people a lot smarter than me, I know you have Ms. April Ross coming to testify, you will hear that the likelihood of a fatality when there is a gun involved in a domestic violence situation increases 85%. Let that sink in. If you have a gun, it's 85% more likely that that woman or man is going to end up dead by the person that should be loving them. So that is what the Section 2 deals with. And I'm just going to hit a few points because I think Senator Albers did such a good job. Revising the Gang Act to clarify res judicata. This really is important in my county and in the city of Atlanta. We know that we have entire apartment complexes that are literally run from the gangs. They're run by the gang members, where I have older citizens that can't go to retrieve their mail or get their mail because you have to pay a fee, or gangbangers are out there and they're not free to just move around. We've had cases recently where Uber Eats and Uber drivers have actually been shot because unbeknownst to them, they drove into a territory that was gang territory and they didn't know they weren't supposed to be on that street. This is a real thing, and it allows for the apartment complexes that allow this for there to be some civil penalties. So I won't stay on that for long. I also want to talk to you about expanding the venue. Gangs don't respect that if they cross the street, I'm in DeKalb now or I'm in Cobb now, they do their business in the metro. And that is true everywhere. And so it makes it financially feasible and just common sense that if most of the acts that they did happened in Fulton County, but they had 2 or 3 acts that were in DeKalb, that I would be able to prosecute those crimes so we can keep it all together. It makes it financially more responsible for my jurisdiction and for theirs. And that the same thing is true if you have a gang that's operating out of another county, but 1 or 2 acts are done here. They can have those 1 or 2 acts so they can tell a jury the full story of what these perpetrators actually did. And so why that is important. This next section, Section 7, that I want to highlight, I feel very strongly about. Judges are elected. They may get appointed, but the bottom line is they have one boss, and their boss are these voters. The same boss I have and the same boss you have, the voters. And I think the public would really be offended if they did not realize that Superior Court judges were not issuing bonds on gang crimes. That's kind of a no-brainer. We want our Superior Court judges that are elected and answer to us to actually be the ones that review the person's record, see what their gang involvement is, and make an educated decision. We think that it is extremely important that it is Superior Court judges, not magistrate judges that might be appointed for some reason, don't have the background, and quite frankly haven't been vetted by the community. It is Superior Court judges that should be making those decisions. And so so that is subsection 7. But I think what is most important to me is section 10. And that's because it really goes to the crux of what I talked about. And that is the fact that we would be able to use prior acts. Now, we do this in child sexual cases, right? If somebody is molesting a child over and over. But if you have someone that is just a repeat offender of abusing a child, that we would be able to introduce that evidence. Or if it was a disabled adult, as I discussed, or if it was an elder person or a victim of domestic violence. And what I can tell you is the people that do these kind of crimes, they do them over and over. The man that beats his wife, he beats this wife, he beats the next wife, he beats his girlfriend, and we think that it's important that the jury really have that information. The type of person that abuses a child, it's not one child. We'd like to think that. We would love to think that, right? One isolated, ugly event. But that's just not the reality. That's not the truth. He has probably abused those older siblings before that, or his last girlfriend's children. It's important that juries get to hear that information, and that's exactly what this bill goes to. Also, the disabled adult. We all know they're a vulnerable population because they really are, they're adults in that they have reached a certain age, but their mindset is that of a children, and so people take advantage of them in the same way we take advantage of children. And so this section is so important, and I won't go into the effective date, but we really hope, we know that this passed through last year. Some of the things that were more controversial, they have been taken out, but we have not lost the crux of what is important about this bill. This bill is here to protect those that each of us took an oath to protect, and we appreciate your support, and we're asking that it pass this year as well. Thank you.
All right. Mr. Carlson, do you have?
I'll strictly for any questions.
Okay.
That the committee might have.
All right. Appreciate y'all's work on this. I remember the hearing from last year as well, so appreciate y'all continue to work on this through this process. Any questions for Senator Albers or District Attorney Willis or Mr. Carlson? All right. No questions from the committee at this time. If y'all want to sit tight, we have a few people that signed up to speak on the bill.
Thank you.
Thank you. First, I have James Woodall with Southern Center for Human Rights. Good afternoon, Mr. Woodall. How are you?
Wonderful, wonderful. Thank you, Mr. Chairman, to members of the committee. One, let me first apologize to Chairman Albers. We did not get an opportunity again to speak to him prior to us being in opposition to the bill, but we wanted to raise a few points about the legislation. One, we do understand, again, the urgency of us doing something in relation to violence and public safety, as it is an issue that we're all very concerned about, quite frankly. And we're intentional in making sure that, one, the data lines up with the proposals that we're pushing forward. And in looking at this piece of legislation, I want to first go to lines 50 through 70. I'm sorry, on the substitute lines 63 through 69, that references the person convicted of a possession of a firearm by a convicted felon. I want to note in the Department of Community Supervision, specifically related to people who are on felony probation, who have either been incarcerated and then ultimately comes into community through probation. I want to give the specific notes that the commissioner shared. Of the over 245,000 people who are actively under DCS supervision, only 1,289 of those individuals had their sentences revoked. So that accounts to less than 1% of any person on felony probation would get any charge or any revocation across the state of Georgia. Two of the 1,289, which is less than 1%, 79% of those were new charges. 11% were for technical violations, 10% were for conditional violations. And so I'm raising this point because what we know is that research repeatedly underscores the criminogenic effect of incarceration. And so when confined, people are isolated from their loved ones, they're exposed to violence, and they're ultimately further stigmatized. These factors perpetuate crime, not prevent it. And so what we want to see is an investment in preventative measures that have been proven to be effective. Secondly, on line 74 through 79, the legislative intent, I want to just name that is something that we are concerned about, obviously because of just the reality of what works and what doesn't. On lines 94 through 95, the broadness of the paragraph 1 of 1615.3, which obviously is our current law as it relates to criminal street gangs, that does not just include the violent activity that has been detailed as criminal street gangs. It also includes other offenses as well that could ultimately be used in the prosecution under this particular code section. And so we have to be intentional about paying attention to what is being proposed, as well as on lines 148 through 172. Obviously, I want to name that the bill's author included there to be an allowance for judicial discretion for a judge to probate or suspend a portion of the maximum sentence, which is a mandatory minimum. We also want to still note that it is still a mandatory minimum where the court would not have discretion to be able to evaluate whether or not a person can have the entire sentence probated, revoked, or what have you. So we as a center, we are just fundamentally opposed to mandatory minimums as a whole, but do want to name that the bill sponsor did allow for there to be some judicial discretion in that. I'll close by saying that when we talk about judicial reform and criminal justice reform, we are working to repeal policies that have led to excessive sentences for the large number of people incarcerated for violent offenses. That includes people convicted of these offenses, quite frankly. And so people who are convicted under Georgia's criminal street gang activity are still eligible for reform. They should be able to get a second chance. And so part of what future criminal justice reform look like is us allowing for people to be supervised in community, which we know works. The state has proven time and time again that second chance sentencing and second look sentencing actually is effective in us saving money, saving lives, and ultimately making public safety a priority for all of us. And so we want to use evidence-based preventative measures as well as rehabilitative programs to ensure that the aims in which we are all seeking is congruent with ultimately what we're proposing in legislation. So with that, I'll pause and yield any questions, and if not, I'll yeah.
Any questions for Mr. Woodall? All right, none today. Thank you. Next, we have April Ross with the Family Violence Commission. Ms. Ross, how are you? Good.
Probably can be heard from right here. I'll just sit right here. It's just good.
You're good.
All right. I won't add much because I believe Senator Albers and D.A. Willis both covered eloquently what the position I take on this bill. On behalf of the Georgia Commission on Family Violence, we are supportive of this bill. I don't know if you are aware, but not only violence has risen in Georgia, family violence has risen in Georgia. The rates at which people are being abused by their spouses, intimate partners and family members has increased, and fatalities have increased. And those fatalities, by and large, are committed by firearm. And so anything we can do to start taking guns away from the violent offenders, or at least punishing the violent offenders who commit family violence against their spouses, their partners, and their loved ones, is going to help save lives in Georgia. And I'm not just talking about the lives of the victim, I'm talking about the lives of the children, the lives of bystanders, including our first responders, the lives of family members, and also sometimes the lives of that abuser themselves who commit suicide in the act. So it is important that we do take steps in this state to prevent further abuse. And also, I'll point out that the section that allows for the previous history to be admissible evidence is really important. Domestic violence crimes are hard to prosecute. I'm saying that from personal experience. I'm saying that from knowledge of talking and training prosecutors around this state. It's difficult because it's complex. The relationships are complex, and victims are not always the easiest and the best witnesses. But what is a great piece of evidence is the history of abuse and that pattern that that person has perpetrated throughout that relationship and previous relationships. And so anything we can do to make that prosecution easier for our state prosecutors is going to be tantamount important to helping to reduce family violence in this state. And so beyond that, I'll just continue to say that this is a strong bill. I think it's a step in the right direction for holding abusers accountable and for saving lives. And so if you have any questions from the Commission on Family Violence, in regards to that, I'm happy to answer, but beyond that, I would support what has already been said.
All right, thank you, Ms. Ross. Any questions for her from the committee? All right, thank you. Next up, we have Mr. Thomas Weaver. Our in-house private citizen. You put private citizen on here, but kind of our in-house private citizen.
Well, thank you, Mr. Chairman, and members of the committee. Get here on the microphone.
There you go.
Thank you for recognizing me to speak, Mr. Chairman, members of the committee. I'm very cautious and very careful here because I do recognize the horrendousness of domestic violence, but I vehemently object to the inclusion of Section 2 to this measure. And my objection, well, in order to move forward, let me take a step back. It's actually kind of clever the way that it's done, but my objection has the same roots. It's a harbinger of what's to come, a canary in the coal mine that doesn't need to be enshrined under Georgia law. And I would hope that this committee would agree with that sentiment. The United States Federal Supreme Court recently, over the course of the summer, released its groundbreaking Second Amendment decision in New York State Rifle and Pistol Association versus Bruin. I note that the Section 2 of the bill doesn't create the offense. It just categorically enhances the punishment. But having shared that, it's still very dangerous for us to incorporate language into our law that the Supreme Court has and now federal courts throughout the country has found unconstitutional. In fact, over the past 3 days, three or four different federal courts, including 2 circuits, have found unconstitutional entirely the parameters of possession of a firearm by a domestic violence offender because it's not cabined to the text and tradition approach as encapsulated by the United States Federal Supreme Court, as wrote and authored by Associate Justice Thomas. So, unfortunately, to the extent that this measure, I mean, again, it's kind of clever because it doesn't really make it a crime per se. It just makes it an element for an enhanced punishment if the offender has that in their GCIC criminal history. But I just think that from a standpoint, from a viewpoint neutral standpoint, in light of that decision and in light of those facts, I would ask that this committee just remove Section 2 from the bill on constitutional grounds. And I would also even argue on statutory grounds because the definition of domestic violence felony, well, it's a forcible felony. And under Georgia law 16-1-3, the term forcible felony is defined as any felony crime that encapsulates an act of violence. So there's really, I mean, I understand the punishment's being enhanced from 5 years to 10 years, but under the forcible felony language, which is already current law under the bill, that's already covered under current Georgia law. So the reiteration, I guess, or the reincarnation of what I shared with this committee last year, and that sentiment remains, except for the only difference is during the course of the interim over the summer, the United States Federal Supreme Court made that ruling, and federal district and circuit courts are beginning to release orders and mandates that strike down that ban entirely. So building any kind of house of cards using that language here, my fear is that it may find itself in the same type of hot water before the judiciary.
All right, thank you, Mr. Weaver. Any questions from the committee? All right, thank you. Next, we have Ms. Maisie Lynn Girton, Georgia Association of Criminal Defense Lawyers, with her guest defense lawyer of the day is an Andrew Fleischman.
Fleischman, like fly then Schmidt.
All right. Welcome. Thank you all for joining us.
Thank you, Chairman. Thanks for having us back again this week and every week that you are gathered here.
Twice a week, right?
Twice a week. I would join Mr. Weaver in just starting by acknowledging the tragedy and horror of some of the crimes that are meant to be addressed by this bill. I hope that the committee won't receive our opposition to the bill as any kind of commentary on victims in our state or the trials and tribulations that they suffer. We simply want to get the law right and want to help you do that to the extent that we can. Mr. Weaver stole some of our thunder on Section 2, I gotta say. We were gonna raise some of those same concerns about current case law, though we have a little slightly additional angle in addition to Bruin that Andrew can tell you about.
I just think that we can't keep whistling past the graveyard on Bruin. Like, it's a huge change. And what the Supreme Court said is that if you have a law that involves the Second Amendment, you have to find a historical analog from the time of the founding to show that this is part of our nation's history regarding the laws about firearms. And the Fifth Circuit Court of Appeals just 2 weeks ago, Judges Ho and Edith Jones issued an opinion about domestic violence restraining orders and whether you could take away the right to bear arms for someone subject to them. And while acknowledging that this law saves lives, that it's an important law, they said it couldn't survive Second Amendment scrutiny because at the time of the founding, there is simply no method of restricting someone from possessing firearms in a civil domestic violence proceeding. Now, this is criminal. This is distinct. So we'll be talking about felons. We have that going for us, but we should think about the history of felony restriction laws when we do that. The first laws banning felons from bearing firearms in this country were passed in 1962. Georgia didn't join that until 1981. So while there were laws against Black Americans owning guns, Native Americans owning guns, there were laws in England against Protestants owning guns, there was no law against felons owning guns. In fact, if you look at the Militia Act of 1792, which is one of the founding documents for forming our armed forces, every white man 18 to 45 required to have a gun. No exceptions for people with a criminal history. So we should be worried if we are stacking up felon firearm possession counts, no matter how good the public policy reasons, we should be including a section of findings about the historical analogs y'all are relying on. I'm not saying these laws are a bad idea or you shouldn't pass them, but if you want them to get past a court and to show you've thought about this, you should say, this is analogous to laws against 18th century laws against carrying arms publicly to cause terror, or these are analogous to laws banning Native Americans from having weapons, or whatever it is you want to do. You need that analog, or else you risk judicial scrutiny overturning it. I'm not saying you have to strike this or keep it out or never do it. I'm saying that the safest way to do it is to make those findings that Bruin and Rahimi and a bunch of other cases are requiring. That's how you make these things work.
I'm gonna, go ahead, what are you?
Sorry.
Moving on to another topic.
Yes, I was going to move
I
to the
just
next
wanted to, so Mr. Weaver also mentioned that there is a coverage in our law right now in this regard, and I just wanted to give you all that cite so you'll have it. OCGA 1611-129 B2E. It prohibits firearm possession by a person that is prohibited under federal law when that's 18 USC 922N. I didn't say this at the beginning, and I really should have. Last year, as Senate Bill 359 made its way through, we had a conversation with Senator Albers. We sent him a memo on his bill. And I do want to acknowledge that in this particular section, one of the changes that he made is something that we asked for, and that is that this section previously had some mandatory minimum language in it that was removed. And so I just wanted to make that acknowledgement that.
Which section is that?
This Section 2.
Section 2.
Mm-hmm.
Can I ask you one thing?
We have issues with the rest of them.
While we're on Section 2,
Yes.
so Section 2 is basically an enhancement of punishment, correct? So it's not a new offense. Doesn't that change the analysis a little bit?
I think the problem is that if we keep passing new laws without addressing these Bruin factors, like when we have the opportunity to go ahead and put those findings in, we are exposing those laws to risk. I'm an appeals attorney. I'm a criminal appeals attorney. I can tell you I will challenge this law personally on that basis. And if you had some findings, it would make it harder for me.
Well, the law is already in the books. We're just increasing the punishment for the offense.
I mean, that's 100% true. And maybe in that sense you would not, but we do have to worry about domestic violence and felon restrictions because of the history going back. And I do think getting some findings on that would be smart.
I guess I would quibble a little bit with the idea that it's only an enhancement because you are adding additional elements. Like, for instance, in lines 38 through 40, this new idea of a domestic violence felony. This is a new creature under this bill. And, for instance, in line 38, we have concerns about this idea of attempted use of physical force or threatened use of a deadly weapon. Those are pretty vague ideas. Rather than say the use of physical force or the use of a deadly weapon. So, I mean, to the extent that, yes, this is enhancing, it's also creating new elements of a crime. So again, that might be something for the higher courts to parse out whether or not this is just pure enhancement versus law creation. But I think there's certainly an argument to be made that this is a new creature in some ways because of these new elements of domestic violence felony.
And what's kind of worse is it seems to import some of the federal language from the Armed Careers Criminal Act, which the U.S. Supreme Court has held as like unconstitutionally vague, and which is sort of a nightmare to administer. And in all these cases, people are like, oh, was there an attempt at violence? And what does violence mean? And do we look at the category of the offense? If you look at how those ACCA cases go in the 11th Circuit, they are just an ugly mess. And I would say if I were writing a statute like this, I would want to stick to Georgia law and Georgia terms that we are familiar with that already have definitions.
Before we get past Section 2, there's one other. It appears that, and we understood that this section was meant to address felony behavior, but are concerned that at line 69, by including the disjunctive or, and then using involved the occurrence of an act of family violence, that potentially opens the door for misdemeanor behavior, which would be easily fixed by adding some clarifying language to say, for instance, of a felony act of family violence rather than an act of family violence, just to be clear. If that was the intention, and that was what our understanding as we've talked about this bill over time was, that was to deal with felony behavior that happened beforehand. And that's what I understood even from the testimony today so far. 69. So as it reads now, it says it involved the occurrence of an act of family violence, but to clarify that it is meant to rest on felony actions that occurred previously, we would just suggest adding, changing it to of a felony act of family violence, if that was the intention. We would like to, I just want to address briefly in Section 3, assuming that you've said all you would like to say on Section 2. So on Section 3, not new language to have been discussing these findings, but I would just, we actually went back to try to find the report that was issued by the House. There was a study committee on gang and youth violence prevention that was chaired by Representative Gilliard back in 2019. Unfortunately, the link to that committee's work is no longer active, and my attempts to track down those reports have failed before today's hearing. But I do wonder if the findings here relate to the findings that resulted from that work, because they spent a lot of time looking into this issue back in 2019. We are going to just skip ahead to Section 6.
Yes.
And I'll let Andrew take this one from the lead.
I think the idea of letting one county grab gang cases from around the state might not be a good one. I mean, for one thing, if we're looking at Fulton County specifically, the ACLU looked at their jail and found that there were people who'd been there 6 months or more who had not even been indicted yet. The jail is seriously overcrowded. There is a gang problem there. Bringing more gang cases and more gang problems there might not be advisable. There's also just the simple problem of the race to prosecute you might have. Now suddenly you've got prosecutors in different venues seeing who's going to bring the case first, because they could bring the case against the entire gang at once. And what happens to those double jeopardy problems that can be created? What if, I don't know, Brunswick brings a case against a gang and they lose? There's an acquittal. Well, at that point, how does double jeopardy affect a prosecution in Fulton County that might otherwise have gone on? What do you say about what that jury necessarily found when they issued that acquittal in Brunswick that might apply to Atlanta? Again, I'm a criminal defense appeals attorney, so if I saw that in a conviction, I would be very excited. I would say, oh, how am I going to show double jeopardy bars this new prosecution? How am I going to show these necessary facts under Yeager, which is a 2009 Supreme Court case? I know I'm the fox guarding the hen house here, but I'm just telling you how I would get the chicken.
Are there other crimes in the code where that's good? Are there crimes in the code where you have multiple jurisdictions like this? Are there examples?
I mean, there are other examples. I mean, for instance, in case where you have somebody going on a high-speed chase with police, then potentially you could go into several venues at once. But at least there's an actual action by that person, and you're not potentially. I mean, gang cases are big. So if you charge the leader of a gang in one place and he's acquitted of leading a gang, or there's some finding by the jury in some direction that there is no gang, how does it affect prosecutions in other areas? I don't know. You're mushing together a bunch of stuff in a way that might not be advisable.
And it's only, I mean, and there was one of the changes that we noticed in the sub from the original that we received this afternoon is at lines 115 and 116 at the end of section 6. And this only exacerbates the problem that Andrew's describing because it allows successive prosecutions in a way that the law does not today.
So traditionally in Georgia, if you are prosecuted for a crime and you are acquitted, the state gets like one shot to get in everything against you. So if you are accused of punching a man and stealing his stapler, okay, the prosecutor can't charge you with the stapler, take you to trial, and then come back and charge you for punching him if they lose. That's what procedural double jeopardy does, and it's great. It's a Georgia-specific thing that applies to every crime, except the exception would be this one crime. Meaning, I mean, God forbid, what if an innocent person got prosecuted? I mean, they are presumptively innocent, and they are acquitted. And they could be brought then to trial in another jurisdiction, and another, as long as we allege slightly different facts. And let's think for a second about how broad the definition of street crime is. It's 3 or more people who conspire to commit, for instance, racketeering activity. In 2014, we had 3 court reporters. They were 3 little old ladies, and their margins were too big on their transcripts. They were each convicted of racketeering for stealing money from the county by making their margins too big and their fonts too big to get more pages out. And it's just a matter of judicial grace, prosecutorial grace, whether or not they're a street gang. You're talking about punching a big hole in an important right and leaving it to prosecutorial discretion whether or not we'll maintain that right. I don't love that. And how does 1617, if you were acquitted of the conduct, then how can we say we're going to remove double jeopardy protections from you? There was no finding you did it in the first place. All they had was probable cause. I'm sorry, that concerns me. And it's the sort of thing, we didn't create this rule for no reason. We had a reason we didn't want people to have to be acquitted more than once to go free. We wanted finality in our cases. And finality isn't just cutting off appeals. It's not just cutting off opportunities for a defendant to go forward. It's having the state take one shot, its best shot, and be done. You take that away, we create real problems.
One other concern we have about Section 6 is at line 109. It's a very broad inclusion of in any county in which an interest in or control of any real or personal property is acquired or maintained. It arguably extends to any county where any alleged gang member then resides, even if that gang member is not necessarily involved in the indictment being prosecuted.
You do have a question about this section if you're ready to
Sure.
take that from the committee. Senator Hatchett.
Thank you, Mr. Chairman. So you're saying that this code section here would allow, if you went on a crime spree that went around 30 counties, for example, you could get tried in each one of those counties
Yes, potentially under
for the same crime.
Not for the same offense. You would have to be slightly different each time. But let's say you led police in a high-speed chase, and you sped in one county, you sped in the next county, you hit a car in the third county. Yeah, you could be charged on each of those successfully, and the jury might acquit you on each and say he wasn't speeding, he was driving perfectly safely. But without 1617, the state doesn't have to take it all at one bite, all at one go. They get to take more than one shot. And the idea of doing it in different venues, constitutionally, venue is important. The idea that you wouldn't be charged for a crime in some random place that you've never been to is actually an important right that we deal with federally, that we make important. Taking that away at the state level, it sucks. It seems like we're taking away an important right for the convenience of the state and for the convenience of Fulton County, a place that seems clogged already. It's like a man choking on a chicken bone asking for more chicken wings. I just don't see it. It's sorry.
No, I mean, well, and Mr. Chairman, if I can just follow, is there anywhere else in the code section in Georgia now where this could happen?
As far as I know, 1617 applies to every offense. This would be the only exception for it. So we have never before seen a reason not to have this rule. I don't see why we see one now. And I haven't heard an explanation for why it's necessary. Maybe there's a good one.
Okay, thank you, Mr. Chairman.
Okay. And I'd love to get you a very definitive answer on that, Senator Hatchett, but and we can circle back on it. But this language that's at 115 and 116 is what obviously is taking away the application of 1617. So I just need to do a quick search and see if there are any other codes, any other places where that language is stripped out.
Subsection 7.
Subsection 7. So this is the portion of the bill where it talks about the Superior Court judge being the only person able to write a bond in a criminal gang act case. At this point in time, the idea that we're going to limit the ability for courts to process bonds when there's so much happening within the bond space of our code over the last few years, there've been a lot of curtailing of who can write what bonds, what charges are bondable in certain ways, whether with unsecured judicial release or if they require securities. And as Andrew mentioned, we've got some evidence that here in Fulton County, our jails are exceptionally backed up. So the idea that you're going to limit the number of judges that can hear bonds on cases, when we're also hearing that so many of our cases these days are gang act cases. Obviously, it's a policy decision for you to make, who you want making those decisions. But we would suggest that that's just going to add more gum to the process that's already having a hard time being effectively executed.
And the current rule is nice and restrictive. It's like for murder and a small subset of cases, life imprisonment that are nice and clear. But gang act crimes are broad.
Yeah,
and there's a possibility for gamesmanship.
And I think one of the examples that was mentioned earlier was a murder. And so I can't explain why a murder, that is a Superior Court only offense. I don't have any explanation for why it was handled by a magistrate unless there was some designation offered. But murder is a Superior Court only bond at this point in time today.
Remember, street gang crimes can include tagging. If I am the Mario and Luigi Club and I tag Mario and Luigi and I'm part of a street gang, I can't get bond except through Superior Court. I might have to languish in jail for weeks.
So I think, Andrew's point being that there are a number of non-violent felonies that would be predicate offenses to substantiate a criminal gang act charge, and you're basically saying that those people also cannot receive a bond from anyone but a Superior Court judge. Did you have a question? You're looking like you might.
You have a question about this section, Senator Kennedy?
I do, Mr. Chairman. Section 6, are we still on that?
Well, we can go back.
Yeah.
Oh, well.
Happy to.
And forgive me, maybe I'm just not getting it, but I'm having trouble reading or understanding where you're getting from reading Section 6 that the double jeopardy provisions somehow don't apply or are impaired or evaporate under a reading of this. I get the reading where there can be prosecutions in different counties based upon the conduct occurring in different counties, but help me understand why that somehow removes the double jeopardy protections that's found elsewhere in the code.
There's a new section that got added just before this hearing that does that.
Line 115 and 116 of LC 49-1252S. It's because it removes the application of 16-1-7, which under our law disallows multiple prosecutions for the same conduct.
Okay.
But by removing it, it's now going to allow that to happen.
Okay. Thank you. Thank you, Mr. Chairman.
Moving on. Section 8, we'll join our friends at the Southern Center to say we don't love mandatory minimums. I've given you my explanation of that over time several times. I will not belabor it today, but we would love for the mandatory minimums to come out of this bill. They are in Section 8 at this time. Section 9. Oh, and you know what? We don't have any comment on Section 9. Look at that. Look at that.
I think it's actually
so
I just want to leave just that one section in.
I think it's a good addition. We could just pass that bill, Chairman. Section 9, just pull it on out.
Senator
make its own
Albers
bill.
about that.
Section 10, though, does give us pause because here we've come from Section 9 where there's this idea that we're going to prevent ambush. And in Section 10, we're going to, in some very real ways, revive it, but only for the state.
So traditionally, all the stuff that's mentioned here is admissible under what's called 404B. So if I give you a piece of paper ahead of time that says, I want to show intent, like for instance, this man is a domestic abuser and he beats his wives when he thinks they're cheating on him. That's motive. I can bring in other times he's done that. Or he beats his wife when he thinks she's going to leave him. That's motive, or that goes to intent. It's not an accident like he claims. All kinds of ways I can bring this in. This takes all that stuff out and makes it just automatically admissible. And what's worse, automatically admissible for the state only. So, for instance, there are cases where women killed their abusers. And here, if that woman has ever fought back against her abuser, that comes in automatically under this. The state gets to bring it in. She gets no reciprocal right to bring in the fact that he's beaten her or hurt her 100 times in the past. It strikes me as crazy. Or if skinheads break into my home, because I got a Jewish last name, they're wrong, by the way, but they come in and they shoot, and I have to shoot one of them, and I'm prosecuted. I can't bring in automatically their history of hate crimes to show why I might have been motivated to shoot them, but they could bring in anything I said, I guess, against skinheads. It's weird that you would not make this reciprocal, especially when the previous section, subsection 9, makes clear that both parties can bring in 404B evidence. And all that happens with 404B evidence is I give you a good reason why I think it's relevant, and if you don't think it's substantially more prejudicial than it is probative, it comes in. That's a pretty good system that works unless for some reason the probative value is way outweighed. But here, you don't even have to give a reason. It shall be admissible. So I could admit this stuff to show the person is a jerk. So I could admit it for the propensity to show he's likely to commit the crime again. There are reasons why we have built these safeguards into 404B about not allowing propensity evidence in, about making it sometimes somewhat difficult to bring in other crimes. And that's because we worry about the presumption of innocence being gone. If a jury hears that someone has committed a crime 2 or 3 times before, they might think to themselves, well, he might not have done it here, but he's guilty of something. They might convict even when they're not sure. And that is a real worry that we have. And if you talk to juries after the fact, it matters. So if we make this stuff automatically admissible, we aren't just making the state's job easier, we are making false convictions more likely based on evidence other than the evidence in the case in chief. Because again, this does nothing in a case where the woman says, he hit me, she got a black eye, she took pictures, a neighbor backs up that she heard shouting. Those cases are still just as strong. What this does is it buttresses particularly weak cases that might not otherwise result in conviction by bringing a bunch of stuff that might not otherwise be relevant. I haven't heard an example from Ms. Willis of a thing that would be useful to have in a domestic violence case that you cannot already get under 404B. And I'm not sure I can think of one. That would be a question I would ask because I'm curious about that. Maybe there's something I'm missing, but I can't think of an example of something that would not already be admissible that this puts in. All this does is strip the judge of jurisdiction to take a look at it himself and see, is this really something that's going to help this case? Is it relevant, or are we going to spend hours diverting the jury on something that doesn't matter? All right.
Any questions on that one? We're almost done.
And the effective act part seems fine to me.
Wait. No, we're not.
Any questions from the committee? We do have a question. Senator Jones.
On that section 10, is that now basically how you do the DUI, where a DUI can come in? A DUI is a DUI. Okay. And so now we're basically saying, though, that domestic violence kind of fits that. I see.
It's broader, though, because a DUI is going to be a conviction that comes in. This is not limited to convictions. This is propensity evidence, Senator Jones. That's what this is. And as you know, Andrew has said, there are legitimate ways in the law right now to get in evidence of intent and motive, which often sounds a lot like propensity evidence. But we are very careful in the law to not bring in propensity evidence because it's simply more prejudicial than it is probative. It's a hallmark of our law. It's a hallmark of the way we practice. This would be a huge and very substantial change to the way that we consider the presumption of evidence and what is required to take someone's liberty from them.
How about the argument, I guess, that's difficult to bring in those persons to testify in those particular cases to establish the 404B requirements that you would have to do as a practical matter? Just throwing that out there. Extremely difficult.
Well, you don't need to bring in the person. The officer who arrested you, the friend who heard about the offense, these are all ways of bringing it in, even if you might not bring in the victim. And of course, this doesn't make bringing in that evidence any easier. It's not a hearsay exception.
Right.
And I'm not sure a hearsay exception would be okay, because that would be someone talking to the police about something bad you did. So that would violate the confrontation clause. Mm-hmm. And that's something you can't get passed with any law you pass.
Gotcha. Thank you, Mr. Chair.
Any other questions from the committee at this time?
I just have one additional small suggestion.
One other question.
If you were to keep Section 10, which clearly we hope you don't, we would suggest that it is the type of section in this bill that warrants special attention in the effective date. So if you look at lines 237, Section 10 is a lot like Sections 4 and 9, and it would be our suggestion that 10 be included there so that it becomes prospective, clearly prospective, just for clarity on the application of Section 10. It's such a big change.
All right, you have a question from Senator Hatchett.
I guess I was going to see if you could help me with some clarity on this. In Section 10, obviously it says evidence of the accused commission of any other, and then it goes into the family violence, cruelty to children. You know, it has its own. What do you think the accused commission would be? What evidence would they be allowed to bring in?
Just somebody said it happened.
But is it now an exception hearsay, or would they have to come?
They would still have to bring in those witnesses, but it would allow, for instance, if a detective looked at a case and said, there's no evidence here, this case sucks, I'm not going to bring it, this could still come in through that. And you might not be able to get that detective to come testify for you that the case seemed weak to him. It might not be relevant. So it allows bringing in cases where the evidence is particularly weak that might not otherwise come into court.
Just by bolstering the evidence against somebody because of their past acts, or evidence of their past acts.
Just because somebody accused you in the past doesn't mean you did it. And sometimes people, it's crazy enough, they could be falsely accused more than once. Certainly in the divorce context, we do see claims of abuse go back and forth a fair bit, and each party claims against the other one, and then whoever gets prosecuted first, well, then the other person's prior claims will all kind of come in without the judge taking a look at them and saying, is this relevant? Does this make sense to me? Is this more probative than it is prejudicial? Those are just good safeguards we built in because we trust judges to do their best to provide fair trials.
Thank you.
On that same note, what about the idea that a lot of these offenses are so difficult to prove because it may be the only witness is the victim? Is there not some argument that the past acts should come in to, from the propensity standpoint, as you said, given the fact that you have such limited ability to have other witnesses in some of these offenses?
Well, I'm not aware what the statistics are for conviction rates in domestic violence cases. I mean, if the victim is coming in and testifying, I don't know whether that conviction rate is 1% or 99%.
Yeah, I don't either.
So maybe that's the, but if that is the argument, that I would like to hear some numbers to show these cases we're losing these cases, we're not getting them. We need this in order to win these cases we would otherwise lose. But what I would say is that if there is long-term abuse, there's usually other evidence than just the victim saying so. There will be bruises. There'll be missing work. There will be other ways of knowing that you can use to bring that stuff in. Certainly, in the context of representing women who have killed their abusers, you find ways. We don't have any law like this, but you find ways of showing the family member saying, "Oh, she came to Christmas and she had a black eye." Or she just seemed much sadder after she got with him. And all those things are admissible evidence. And juries understand this, right? Juries understand that women are not desperate to go make their abusers mad. I just think, it's G.K. Chesterton was this famous English conservative, and he said that if somebody built a fence somewhere, you shouldn't tear it down unless you're sure why they put it up. And I don't feel like the people who suggested this bill have thought enough about why we have these rules in the first place before they wanted to tear them down.
Are any other questions from the committee? All right, thank you.
Sure, thank you.
I believe, so we had George Jenkins and we had Mark Belknap. Are they going to testify separately? You guys, are you part of the?
Together or separately?
Well, I didn't know if y'all were part of the original presentation. You want to testify yourself individually?
Well,
come on up. No, you're good.
Sure, absolutely. Thank you. First of all, thank you all, Chairman Strickland, obviously Senator Albers, Madam DA Fonnie Willis, my colleague Mike Carlson, and others here, and other committee members. I am here as an executive DA from the DA's office here at Fulton County. I prosecute the less sexy crimes, I guess you can imagine, the divisions that I supervise. That means your armed robberies, your hijackings, your trafficking and narcotics cases, your entering autos, and I am here to lend my support as I did last year in connection with this bill. Mr. Carlson, my colleague, certainly is our evidence expert, as you guys all know, those who practice law here and have witnessed his testimony before. I'm here to support this bill. I think it's necessary. This, to me, as a prosecutor here in Fulton County for the last 17 years, quite simply, if you're not a part of the solution,
of this rising crime and gang activity, then you're part of the problem. And it's something that we are dealing with that requires action, and that's why we have this bill. And we hope that certainly you guys will do the same thing you did last year and approve this measure and send it over to the House in connection with our requests. We have made adjustments to this bill with our fine work with Senator Albers, trying to fine tune and specify certain concerns that you may have had last year, and I think we've done that. And so I can tell you that it's necessary, it is important, and I'll tell you, and I'll give you an example as I think Investigator Belknap for the Gang Association will talk about specifically. I see these crimes, I've seen these issues and what gangs have done to the community, specifically in these apartment complexes. I mean, as a prosecutor, a line prosecutor for many years, we simply know, depending on where you are in the city of Atlanta or any in the metro area, that are just overrun with gangs and crimes. We simply know, I know the addresses of like 15 of them here in the city of Atlanta. As a matter of fact, we have a collaboration, our office with the mayor's office, the city solicitor's office, and the reason why we have the res judicata part in this section in this bill in connection with potentially how do we address these issues. You've seen the articles in the AJC in connection with addressing these crimes in which these gangs and this violence in terms of trafficking, narcotics, firearms, human trafficking for that matter, although that's not my area, and terrorizing the citizens and how would you say, recruiting the youth in these areas. It's very true. I think that, and I've seen that increase in uptick in all the types of crimes that I supervise and I actually have personally dealt with at Fulton County. And so I think this is very important. We cannot rest Atlanta, everyone wants to be here, right? In terms of what type of community are we going to have for citizens that want to enjoy, to live, to visit, to whatever they want to do, to exercise their constitutional rights as law-abiding citizens of this community in this country. And it's our job and duty to make sure that they do that safely and comfortably here in Fulton County. And so there isn't a whole lot I have to add other than that, and please do what you did last time, ladies and gentlemen of this committee. Please support and any questions you may have for me in terms of my experience as a prosecutor, firearms. There's another thing you don't hear about it, and I know everyone thinks and has probably had some experience with it. You know, since we've come out of COVID, the amount of cases that I supervise, that we prosecute in our division, our road rage incidents, those crimes and domestic violence, use of firearms, and the uptick of such. It's just remarkable. We see it and we're dealing with it, and we're on the front lines of it, and we ask you to help us in combating that issue. I'm open for questions.
All right, thank you, Mr. Jenkins. You have a question, Senator Hatchett.
Yeah, I was just going to follow up with you as well on this double jeopardy issue that was brought up earlier, and see if you had any, what your take on that was.
Well, my take is it simply doesn't, you know, I understand his job as an appellate attorney is to see problems before they happen, but it doesn't affect the double jeopardy statute here in the state of Georgia. You know, if we decide to, it's basically where do you decide to prosecute the case, and I think it's consistent because I don't think he's challenged the RICO statute here in the state of Georgia, and that in this statute here, in the gang statute and the venue statute, was kind of patterned after our Georgia RICO statute. You know, wherever this person commits a crime or has proceeds from those crimes in any county, they can be prosecuted at that location. And once they get prosecuted for those crimes, well, double jeopardy is something we learned in law school, and prosecutors aren't going to be going around, hey, okay, well, we lost this case, let's get him on this case. That's simply unethical in my opinion, and I think the statute is clear on that. And so I don't know, and I disagree with his analysis in connection with the potential double jeopardy issues in connection with the venue statute in this bill proposal.
Thank you.
One follow-up question on that. Do you know if our RICO statute does have the exemption of OCGA 16-1-7 as well.
You said exemption?
Yeah, because what you have on line 115 of this bill provides that 16-1-7 shall not apply, and that's the statutory multiple prosecutions. I'm looking on this computer.
It's
law.
my understanding that it does, Chairman.
Is that also the case under the RICO statute?
Yes.
Because it was brought, I think Maisie Lynn didn't know the answer without searching that, whether, looking for you in the crowd now. Any other places in Georgia code where that was excluded, but you're saying it is excluded there as well?
Yes.
Okay. Any other questions from the committee? All right, thank you.
Thank you.
Sorry,
Earlier you said you were not aware of any places you hadn't looked at yet to see if 16-1-7 was
precluded from other.
right. And it was mentioned that the RICO statute that doesn't apply there.
Oh, interesting. You'll sit and
Okay.
good to know.
All right.
I mean, the good news for them is that a lot of times right now they're charging RICO and gang right side by side, so there's that.
So it's consistent then in that standpoint. Last person to speak was Mark Is it Belknap? I'm saying it wrong.
Belknap with a silent K.
Oh, that's easier than I'm trying to say it. Come on up, Mr. Belknap.
Dealt with this my whole life. So.
I'm sure.
Yeah.
I go by my middle name, so I've dealt with that my whole life too. So, good evening.
Yeah, good evening to you, and thank you so much for having us here. I'm here today to represent the Georgia Gang Investigators Association. I'm the vice president for the organization. Just a little background on me, since I haven't appeared before this committee before. I'm also a law enforcement officer. I've been employed in law enforcement for 17 years, and I've spent the last 13 of those years as a gang investigator, first as an officer and then as a detective for the last decade or so. I've served on state and federal task forces. I often serve as an expert witness in Fulton County and other areas around the state pertaining to criminal gang activity in both criminal and civil matters. And I've served on the GGIA board for several years, which is why I'm here today. The GGIA is here to support this bill to strengthen the Gang Act. And as you know, the GGIA exists largely as an organization to provide support, often through training to investigators and prosecutors, and best practices for investigating and prosecuting criminal street gangs. We've also supported law enforcement by offering surveys to assess the level of criminal gang activity around the state. A number that you've likely heard over the years is our 2018 survey result that found criminal gang activity in nearly every county in the state, as well as an estimated 71,000 gang members across the state. And I feel like what's often lost in the discussion of that number of criminal gang members is that as the number of gang members has increased, the number of victims of gang crime has increased as well, and often in larger numbers than the number of members because they frequently commit multiple crimes. So behind every Gang Act violation charged is one or more victims who've lost something. Sometimes that's property, something of value that they've worked for. Sometimes it's their innocence, and often in many cases, and in more cases now than we can remember, and in many of our lifetimes, people are losing their lives. So this bill addresses several areas of particular concern to criminal gang investigation and prosecution. And it's important to note that gangs have evolved quite a bit. And I think when we say the word gang in Georgia, often we still picture local neighborhood crews, just groups of kids kind of getting into mischief. And that's not what we're dealing with anymore. Our gangs have evolved far past these local neighborhood-based groups into large, nationally connected criminal enterprises that are much more organized than I think that most people recognize. Those criminal organizations, in many cases, choose a path of least resistance when they're choosing the victims of their crimes, and they often choose them from the most vulnerable among us. That includes the elderly, those special needs adults and children, other marginalized groups, and even those within their own households. So this victimization often occurs through gang recruitment, something that's been mentioned already today. They target marginalized youth with their recruitment activities, enticing them with promises of money, power, and respect before essentially stripping them of any real chance of achieving any of those things. Also, gang crime is not restricted to just one area or territory anymore. These criminal organizations ignore or even take advantage of jurisdictional boundaries to commit crime all over our state, and it diffuses the effort to investigate and prosecute gang crimes. So this bill would close that loophole and allow juries to hear and adjudicate the full picture of gang crime in a particular case, as has been possible, as we've discussed, via the RICO statute for over 40 years. It's important to note that not all gang cases are RICO cases. They're different statutes for a reason, and they have different purposes. And allowing us to bring in that full picture, I think, is very important to our ability to prosecute our gang cases. And from the perspective of GGIA, it's our expectation that this type of prosecution is going to happen by consent and with collaboration between the different jurisdictions that may be affected by this. And I'll come back to that in just a moment. Additionally, as it pertains to the issue of bond being heard by a Superior Court judge, I agree with some of the challenges from both sides about this issue today. And I think that in gang cases, the stakes could not be higher. And I think that's actually exactly why this should be heard by a Superior Court judge. Criminal gang members pose a serious threat to our community. And to the extent that we want to ensure that someone who's accused of criminal gang activity is not overcharged or over-prosecuted, I think it's important that a Superior Court judge hear that. The example was raised of gang tagging. Seems like a very low-level activity. However, gang tagging has a very serious purpose. Gangs tag communities to claim territory that they will hold with violence. It's also a notice to the community of who is now claiming this territory to intimidate them from being good victims or witnesses in the case that they are a victim of a crime. And I can tell you that witness tampering is the #1 problem we face in our criminal gang prosecutions. And therefore, I think it's extremely important for a Superior Court judge to consider bond to help us combat that issue. The final point I'll make is that this bill enhances cooperation between law enforcement and prosecutors and gains from the shared energy of other projects that this committee has undertaken. I've worked on the Formulytics project since its inception over 10 years ago, which is kind of hard to believe. And this platform was designed for just this purpose. It's to help investigators and prosecutors go further faster by building clear, effective prosecutions against criminal organizations and facilitating safe and smart sharing of intelligence across organizations. And this software platform and its prosecution model combine with this bill not to form a tool of mass incarceration, but instead, and contrary to that, to provide the necessary tools for law enforcement and prosecutors to ensure that the victims of gang crime are able to receive justice in our courts. The goal is to fulfill our duty to the public to effectively prosecute those who commit gang crime against the peaceful and often vulnerable citizens of our state. So what Formulytics does is make technically possible what this bill proposes to make legislatively possible. So that is just some of our comments about this. I'm glad to answer any questions you may have.
All right, thank you, Mr. Belknap. Any questions for him from the committee? All right, thank you very much.
Thank you.
That's everyone that's signed up to speak. I'll ask Senator Albers, Ms. Willis, and Mr. Carlson if y'all step back up. There's 2 questions I have, and I'll see if any other committee members have questions outside of these. First question that I have, looking at Section 2, there was reference to, on line 69, the act of family violence and not saying whether or not that included misdemeanor. It looks to me like looking at lines 50 through 59, it has to be a felony based on that language. My read of that, if I'm correct, is there any harm in adding the word felony, a felony act, adding that phrase on line 69 as was requested? Or am I missing something?
Are you suggesting that we add that language?
I'm asking. That was asked by one of the people testifying earlier. I can't remember who it was now, if it was Ms. Gurdon.
I have no issue with it making that add.
Am I right that it has to, based on the language in section, let's see, lines 48 through 59, it looks like it only covers felonies anyway. Is there any intent to include any misdemeanor family violence offenses?
I think if that's to clarify it, I think that's perfectly reasonable.
None in this legislation.
And I can ask Ledge Council if you think that there was a request for adding on line 69 after the occurrence of, I think it would be a felony act of family violence. Is that necessary? Which mic are you?
Number 3.
3. All right.
Chairman, I was of a mind with you that it has to be a felony. I don't see that it would cause any problems unless someone who's more familiar with the bill than me thinks it would to on line 69 spell out occurrence of a felony act of family violence.
Okay. All right, thank you. The other question I had, we've talked about this, I'm sure you're prepared to address it. Why are we excluding on line 115 of the substitute the protections of OCGA 16-1-7? I think what was said about the RICO statute may not be correct. It looks like RICO has its own venue statute, and it doesn't, it looks like it does not exclude the protections of 16-1-7. What am I missing on that?
May I be heard?
Yes, sir.
The first matter we want to take a look at is what is this bill attempting to do? And the rhetorical question is a three-person mail fraud conspiracy going to receive legislative priority in Georgia, or mortgage fraud, or identity theft? Because racketeering, which would include that three-person mail fraud conspiracy, identity theft, and mortgage fraud all have multi-county venue provisions. So then the question becomes, in prosecuting only the Street Gang Act violations, only the 16-15-4 violations, are those going to be allowed in multiple counties? So the question became in the redraft for this year, because what frequently happens in gang cases is the gang elements are determined at a later point in time, and through a later investigation, we could have the one county that's bringing in the gang charges make those determinations perhaps after disconnected misdemeanors, disconnected other cases were brought. It's generally speaking, across the board, both in Georgia and federally, double jeopardy challenges to the racketeering laws and to the gang statute have failed. So the issue of whether or not this provision, which is not a double jeopardy provision, which strictly saddles the state with bringing all charges in one place at all time, whether or not we should have a specific statutory exclusion from that in this gang statute. That's why that's in there. In terms of the way racketeering cases are brought in this state, they are often brought multi-county and even after the predicate offenses have been disposed of, the underlying defenses have been disposed of, and that's been upheld because the racketeering statutes, of course, just like the gang statute, have been interpreted to have different elements of proof. So all we're saying here is with these specific elements of proof in a gang statute, and they're being brought gang charges from multiple counties into one jurisdiction, we're making it clear that that provision does not apply, and that is not a double jeopardy provision. We're resolving an open issue statutorily here where it was perhaps not done specifically in statutory form in 16-14-11, which is the racketeering statute, and it does not appear there in specific statutory form. However, whether or not successive prosecutions can be brought under the racketeering laws and under the gang laws, in addition to the underlying offenses, or with regard to multiple subsections of the gang statute. In other words, an individual could be charged with an A violation for participating in the offense, a B violation for recruiting, a C violation through the armed robbery, that was a recruiting armed robbery, for obtaining property through the commission of the offense. A B violation is actually committing that to increase or maintain status in the gang. Then the E violation for recruiting plus the underlying armed robbery, all those charges can be brought in double jeopardy, does not apply. So what we're saying here is the statutory, not constitutional rule of bringing them together in one proceeding doesn't necessarily apply in a multi-county gang prosecution, which happens to be brought in one single venue. Under this statute, the way it's allowed again in mortgage fraud, identity theft, and racketeering.
And that's where I'm still not clear. So in RICO cases, you're saying that 16-1-7 does not apply now, and this will be consistent with that, or is this the one place where
I'm not
doesn't
familiar
apply?
if that specific issue has been resolved in those multi-county racketeering issues, and I've discussed that with racketeering expert, obviously John Floyd, and also John Melvin from the Georgia Bureau of Investigation. What I'm saying is the issue's been resolved whether or not racketeering charges or gang charges can be brought in addition to the underlying offenses, and the answer to that is yes. So now we're strictly dealing with the Georgia statute pertaining to having to bring, generally speaking, all offenses in one jurisdiction at one time, and that is sometimes not the way racketeering cases or gang cases work.
Those are the questions I have. Any other questions from the committee for the author? We have a question for Senator Jones.
I had two. Number one, on the Section 2, the Bruin factors that would be talked about, do you think it's necessary to go through those historical factors to survive any type of appeal? That's number one. And then number two, on Section 10, which I really would like to be able to go through, but can you still kind of deal with some of those concerns on that Section 10 that you could get the same thing through 404B procedure that you could by doing this?
Absolutely, Senator Jones. First, if we take a look at what is in Section 2, it is a issue dealing with raising the floor of punishment as opposed to creating a new offense. So in terms of expanding the enabling language before the statute here, we don't believe that's necessary here for those purposes. And in fact, in a recent appeal, which is going to be part of my answer on Section 10, the enabling language was not expansive, and yet the application of the statute, according to the state's interpretation of it, was upheld in order to reverse the trial court. So we don't believe that's going to be necessary in this case, given the way the statute is positioned. We're not adding elements to an offense where someone could get charged with something new, where perhaps arguably, and I'm not going to render opinion on whether that would be necessary even in that case, but it certainly would not be here. So let's go for a second now, Senator, to Section 10. And the first point to make is that, and perhaps it was nerves, but some of our colleagues were misstating the 403 balance for excluding what we call other acts or uncharged misconduct evidence. We kept hearing if it's more prejudicial than probative, if it's not prejudicial than probative. That's not the standard under Rule 403, and one thing this body was very deliberate about years ago when adopting the federal rules of evidence was to make sure that key cornerstone rules like Rule 403 were adopted in specific forms. So we want to make sure, just like with the exemptions from the Gang Act venue proposal and RICO were very clear, we also want to be very clear about those standards. So the question becomes not the admissibility always on evidentiary issues, but the purpose. So, under Madam District Attorney's leadership, in a case we recently appealed, we dealt with a similar statute to what we're seeing in proposed Rule 420 that was signed into law by Governor Deal in cases charged under the Street Gang Act. And that's Rule 418, does not appear federally, allows in other acts, uncharged misconduct for all relevant purposes. And that's the key. In cases charged under the Street Gang Act, 1615-4. So, 420 is not a parallel to Rule 404B. Why? Rule 404B only allows that type of evidence in for a non-character purpose. Sex crime statutes we have at 413, 14, and 15 allow other acts of sexual misconduct in prosecutions or lawsuits pertaining to it for any relevant purpose. We similarly broaden that in Georgia, not quite as broadly, for prior DUI acts, and we did it for prior acts of criminal gang activity. That statute, 418, was challenged, essentially, and it was upheld by our Court of Appeals in a case that said Rule 403 still applies. So now we take a step back. What does this statute do? It not only allows for admissibility of this type of other acts evidence where the defendant has selected a particularly type of vulnerable victim repeatedly. And we are taking the position in this statute that the jury has a right to hear that for any relevant purpose. So if the person physically beat again and again and again someone who's on the autistic spectrum, for whatever reason, perhaps because that person is the sort of victim that doesn't always testify well, this bill says the jury has a right to hear it for any relevant purpose, and that evidence would be presumptively admissible. The judge would still have discretion to exclude it, but it would be admissible. Now, the next question we have is should victims of those sorts of vulnerable types get better justice in felony trials in the state of California than they do in Georgia? This statute was based on a California statute that has been on the books out there for years. As far as domestic violence, multiple states, including Illinois, have a provision just like this. So with the exception of the enhancement here for repeated acts of a discriminatory nature under our hate crime enhancement statute, which was added this year under Madam District Attorney and Senator Albert's leadership, this is essentially a statute that exists at California because these special types of victims and the people who prey on them create situations where the jury has a right to hear more and for more purposes.
Senator Jones, I particularly appreciate the question because I think that's what should not get lost. This Section 10 specifically is really dealing with minors, which, you know, children, they're difficult to testify about horrible things that have happened to them by an adult, someone they should trust. A disabled adult often is equivalent to a child. A domestic violence victim, I'm sure in your long career, they're broken for a lot of reasons. They need this extra support. And so this bill doesn't go to every kind of victim. It really goes to protect a special class of victims, and that's why it's important.
And may I add that statutes like this have survived constitutional challenges. Very often a factor in that is because Rule 403 applies, which is exactly the sort of testimony that was provided years ago with regard to 418, the gang equivalent of this.
All right, any other questions from the committee?
I do a very brief closing.
How
brief?
Very brief.
Well, I won't use up any more time telling you how brief it will be.
All right, thank you for your closing. What's the pleasure of the committee?
Mr. Chairman. I'd like to, with the thanks to Chairman Albers for the good work he's done for a long time, I'd like to make a motion to pass LC 491252S as in Sierra.
We have a motion to pass by committee substitute Senator Kennedy, a second from Senator Watson. Are there any amendments? Seeing no amendments, back on the underlying motion. All those in favor of the motion to pass, please raise your hand. It is unanimous. You need that closing statement after all.
No, I'm good, thank you.
All right, thank you.
Thank you.
Good job.
We will now move back to Senator Albers. Senate Bill 13.
Thank you, Mr. Chairman. I think this one's going to be a little bit quicker and easier for you.
Give everybody 1 second to get out of the room. This one doesn't get as much attention. All right, Senate Bill 13, we're working off of a committee substitute as well, LC 393741S. Is that what you have? Yes, sir. Hold on 1 second.
I just want to ask the senator if he could be as brief with his opening as he was with his closing on the last bill.
I would take your motion to pass now, Senator. Thank you.
No, we're not the Public Safety Committee. We actually have hearings, so now. Oh.
You cut me deep, Shrek.
I don't have any bills before you this year, I don't think. All right.
Not anymore.
Not anymore. Makes my job easier, too. Senate Bill 13.
Thank you, Mr. Chairman. This is a very simple bill. While you'll see a few areas where there's some change in language, it does one thing. It allows today where we have sheriffs and tax commissioners who do auctions to do them online. There are some that are already doing this online because there doesn't have anything in the law that says that they can't, but we want to make sure that we have codified that. It's just that simple. It's the right thing to do. We're going to walk ourselves right into the early 1990s once we pass this bill, allowing us to do more things online. There are no questions. I'll yield.
I do have one question. Line 29, you have a fee set that I guess is like a minimum fee because it's a maximum fee. It should not
Maximum, yes.
exceed, excuse me. Where did that number come from? Because this, we have no current number in the code.
I'm going to bring up my my aide, TJ.
All right. Welcome, TJ. TJ Kaplan.
Thank you, sir. The purpose of the fee and the way that wording is structured is to ensure that the fee is only applied at the time of sale and not beforehand. And 250 was the number that we chose to keep it low and reasonable to cover the costs of an auction being done online.
Okay. You have a question from Senator Hatchett.
Yes, thank you, Mr. Chairman. My question was, I see where it allows for the internet-enabled technology when it's talking about property taken under execution as provided for in paragraph 1, but then the on lines, let's see. I just saw it a second ago. When it dealt with real estate and those, I didn't see, I guess, the internet provision. Is that, or is that still going to be allowed, or what?
Yeah.
Is it just, go ahead, yeah.
Yes, sir. The banking community asked specifically that we exclude foreclosures from this.
Okay.
So Section 2 is meant to specifically ensure that we do not change the foreclosure statute in any way, shape, or form.
That was an issue we had last year.
Yes, sir.
Yeah.
And we
Okay,
took
well, thank y'all for
committee's
addressing
guidance.
that.
Yes.
Yeah.
Yeah, and thank you for that question. We did work very closely with the banking community, as well as great work by our sheriffs and tax commissioners who all provided great feedback with this bill.
Good deal. Thank you.
You have a question from Senator Setzler.
Hey, Mr. Chairman. What classes of property are contemplated in this? I mean, obviously foreclosures are not part of this. Just paint a picture for us. What's included in this and what's not.
So I would defer to the expertise of the sheriffs and tax commissioners in the room, but as I understand it, the judicial foreclosure is contemplated in Section 1. It could be anything from real property down to a sewing machine. The tax levies contemplated in Section 3 would be real property.
So again, the circumstances giving rise to this, or what? What is this limited to in terms of the sheriffs driving this?
I would defer to Terry Norris on that specifically.
Do you want to wait until your speech, or do you want to come up now?
I want you to come up right now.
Well, I don't want you may have another speech to give. I don't want to have you come up twice.
We're trying to limit the speeches for you,
I
Mr.
like that.
Chairman.
Come on up, Mr. Norris.
Mr. Chairman, I am Terry Norris. I'm Executive Director of the Georgia Sheriff's Association and a constituent of Senate District 17.
That's right.
So, the question again, sir?
What could you paint the picture for us of what circumstances are involved here?
Well, in judicial sales, it could be on a judgment based on a lawsuit or otherwise. And it would be the responsibility based on a judicial order to take the property of the person in which the judgment was against, whatever property that might be. So it could be a sewing machine, it could be a vehicle, it could be anything. And then those properties are sold at the sheriff's sale. And the proceeds of that particular sale in that instant would go back to the plaintiff in that lawsuit. That's one example.
Okay. So if part of restitution, this is order, this could be something ordered as part of restitution?
No, sir, that'd be on the criminal side.
Okay.
This was all judicial sales or tax, on tax FIFAs.
That's what I'm asking for. Thank you.
Thank you.
Here are questions from the committee. And Mr. Norris, do you have anything else you want to add? I know you signed to speak on the bill
Yeah,
as well.
we're going to support the bill. It will make things, streamline things for sheriff sales. There's some code now, old code, that says we have to do it on Tuesday at a certain time at the courthouse. This gives the judge flexibility to do that on that side, so it will help us.
All right, you do have a question, Senator Hodges?
Just one quick question. In the basic difference here is that you're using the internet as opposed to standing on the courthouse steps the way it's been done in the past. Will anything change about notice to the owner of the property that's being sold, or the right to redeem?
No, sir. We intentionally did not change anything about how that process works.
Okay. Thank you.
All right, no other questions. Thank you all. One other person signed to speak, and I can't read your last name. Caskey, Adam Caskey. General Counsel for Investa Services.
Yes.
Good
among
evening.
Others. I'll do my best to be brief as
You're
well.
good.
So my name is Adam Caskey. I'm a lawyer, and I don't exactly know how or why, but for the past 20 years, I've spent my career in the tax deed space. So I'm coming to you to speak regarding some mechanics that may not be familiar unless you've done what I've done for the past 20 years. First of all, not opposed to the bill or the concept, but I think it's important because this is a pretty substantial change in the way things are operating. I think it's important to pause because I think there are hidden ramifications to the right to redeem embedded in here that are really, I think, unintended consequences. But I think there's a few things we could do to guard against those issues. What I'm specifically speaking of is once we moved to online sales, particularly in the metropolitan Atlanta area, there are going to be a lot of out-of-state bidders, which is fine. There may be foreign country bidders, which I guess that's fine. It's not my place to say whether it is or it isn't. But what I can promise you is going to happen is it's going to become harder for property owners, banks, other interested parties to find that the party they need to contact in order to redeem their property if they're out of state and there's no registration requirement on the front end for the bidder to, in my opinion, they should have a physical office in the state of Georgia. They should be licensed to do business in the state of Georgia. And the reason being is here's what really happens after the sale. Like on the front end, it's fine, it's easy, I get it. Frankly, it'll probably make my life easier to have online sales. But on the back end, during the first year following the sale, everybody, the property owner, the bank, judgment lien holder, so on, they all have an automatic right to redeem. Nothing that can be done about it. And after that first year, though, things change. One, it gets more expensive. And then two, the nature of the tax deed changes where it can actually wipe out everybody. So it really behooves, if you find yourselves in this situation, it behooves you to take care of this sooner rather than later. But an important factor is going to be is being able to actually track down that tax deed purchaser, procure a payoff number, and actually be able to deliver the payment. And so I believe that some suggested language had been shared with you beforehand. And that's what it's intended to target. And I can tell you, I see this. I've seen this numerous times. And the thing about the statutory tax sale framework in Georgia is, like, on paper it seems easy. I've seen over the years lots of outside groups from New York hedge funds, a couple little overseas groups. They read an article or they go to a seminar and they think it's as simple as I put out money and I get a return. And a lot of them don't account for the fact that they sometimes catch the car and they actually end up being property owners and they actually have to deal with the people. And that's where a lot of things can get out of whack. I mean, I'm reminded a couple weeks ago, my mother, for example, had to wire money. She's pushing 80 years old, and that was like the most complicated thing ever. Whereas if there was a physical place to go to, it'd be much easier. Another thing that really comes to mind, and this was a particular, and during the Great Recession, I remember I had somebody call me in the summer of 2009, and that's just, when it was just tanking, the real estate market. And they had bought a bunch of tax deeds over the prior year, and they just thought, like, oh, well, I'm going to make my percent return and move on. Well, it turns out they ended up owning them, and that was not what they were planning on. Now, that group, they actually did the right thing and took care of it, but I've seen plenty of times where you see these out-of-state people, they just quit taking care of the property, they quit paying the taxes, and it actually goes through again. It goes through the process again, and what it does is it adds to blight, it creates more code enforcement problems. So all we're saying, we're fine with the concept. I mean, we understand we got to get modern, I get it. But you can do some little things on the front end, just from a registration perspective, putting some parameters in place where payments can be delivered. I mean, you have to have an address, you have to have a working phone number. Sometimes, this is an escrow account mix-up that why properties end up in this situation. Sometimes it's someone gets laid off and they need a payment plan. I mean, you see things all across the board, and it's just, based on my experience, I've had to sue people before, some of these groups, and where they just came in and then you couldn't find them. And it's one thing for me to do it. It's another thing for someone who, never been in a courtroom in their life. They're already in financial trouble, then to track down a lawyer to go do this. I just, again, don't have a problem with the concept, but I think there could be some upfront protective mechanisms put in place that would prevent unintended consequences. And I'm happy to elaborate further. I know you guys have already had a long day, so I don't want to keep you.
All right. Any questions from the committee for Mr. Caskey? All right. Thank you.
Thank you.
And one letter in your folder was a letter from the tax commissioner down in Glenn County, Mr. Chapman, in support of the bill. There's no one else assigned to speak on the bill. What's the pleasure of the committee? Motion to pass by committee substitute from Senator Setzler. Is there a second? We have a second from Senator Jones. Are there any amendments? All right. We're back on our line motion. All those in favor of the motion, please raise your hand. It is unanimous. Thank you.
Thank you, Mr. Chairman. Thank you, committee members.
All right. Thank you. All right. Last bill on the agenda is Senate Bill 83. Senator Jackson. We are working off LC 550007.
Yes.
All right, the floor is yours.
Thank you, Mr. Chairman. So I bring this bill before you. This committee has heard this bill in various forms over the years, but we have finally come to a compromise. So this bill is about stalking, and it's specifically about whether or not a person can get a TPO or a restraining order if they are being stalked in their own home. So if you'll notice, my bill does not address the criminal code about that, whether or not we change the definition. I'm not changing the definition of stalking in the criminal code. I am only speaking to the TPO aspect. So what we have in the state of Georgia and across the country, quite frankly, are people who are sharing a home with a former partner or a current partner, someone that they're sharing a home with, and that relationship goes awry. And then one of the people in that home begins to surveil, stalk, harass, intimidate the person within their home. And they do it so that they can't get out. So let me give you an example. So you have a woman who wants to maybe call a domestic violence center to be able to move out. Well, he's tracking her phone so that if she makes that call, he can respond in the way that he seems fit, right? She wants to get out. She wants to move. And then he's watching her in the separate bedroom, which should be a place of privacy, but he watches her and he sees that she's starting to pack a few things or squirrel a few things away, and he prevents that, which often leads to violence. And so we know that this type of stalking happens. There are instances of people who are being watched in the shower, all types of things. And so what I'm doing is simply creating a pathway so that the victim can receive a TPO, a temporary restraining order, or protective order, in order to get to safety. I think I'll stop there and I'll take any questions.
All right, thank you. And as you said, I remember last year, I think we heard this, we were dealing with the criminal definition of stalking as well, and that's come out. You're just dealing with the TPO side.
That's right.
Civil side. And the way I read this, it would be, in essence, like standing. This gives somebody the ability to still petition for a TPO. Of course, it's still the same standard that a judge would look at and decide whether or not to grant it. Is that right?
That's correct.
All right. Any questions for the author? You have a question for Senator Jones?
So as the chair was saying this about standing, so before the person would just be precluded from bringing the TPO without this because they lived in the same residence.
That's correct.
And
so
this just gives them the opportunity, but they still have to go through the process.
That's right.
All right, thank you, Mr. Chair.
All right, we have a few people signed up to speak on the bill. If you want to sit tight, Senator. First, we have Charlotte Jackson from.
I'm the prosecuting attorney's counsel. I'm not
Okay. And so Ms. Jackson from the Prosecuting Attorney's Council is not going to make any comments on this version of the bill. Thank you. Next, we have April Ross, again, from the Georgia Family Violence Commission. Hey, you're fine.
I apologize. I'll be very brief. The Georgia Commission on Family Violence has been working with Senator Jackson on this bill for the last couple of years now, and we're very supportive of it. We believe stalking victims are a unique subset, often of intimate partner violence victims, and they face unique challenges in terms of leaving and staying safely away from their abuser. And so we support the amendment that she's proposing and the change to the stalking bill. Now, I do realize that oftentimes if, under the example given, if people have lived together, there is the Family Violence Protective Order as well, but this amendment to the Stalking Protective Order adds that protection for people who pursue it pursue that avenue. So we are supportive of that.
And I turned it up since you're a little further back. I think that's an important thing to ask you about. So in the world of TPOs, there's the Stalking Protective Order and there's the Family Violence Protective Order. And so the Family Violence Protective Order doesn't have anything that prevents you from getting a Family Violence Protective Order if you're in the same household, obviously, because the family violence a lot of times may occur there.
Correct. And in fact, what this just does is simply strengthens the Stalking Protective Order. The Family Violence Protective Order is still an avenue, and there are different, strategic reasons why one might choose one avenue or the other. But the Stalking Protective Order has been in need of strengthening for a long time, and we are supportive of that.
All right. Thank you. Any questions for Ms. Ross? All right. Thank you. Next, we have Ms. Maisie Lynn Girton, Georgia Association of Criminal Defense Lawyers. You want to come up to the mic still? Yes, that way you can be live.
We raised some concerns last year with Senate Bill 197, worked with Senator Jackson to get to where we are today and have no position on this bill.
All right, thank you.
Really appreciate her working with us.
All right, next we have Judge Paige Whitaker.
And I was only here if there were questions, but it sounds like everybody's sort of in agreement.
Well, we have one more speaker, so we'll let you sit tight. Ms. Whitaker will be on standby, Judge Whitaker. Last person out to speak was Thomas Weaver. And Mr. Weaver, I believe we have a letter in our folder you submitted for the committee as well. Good evening.
Good evening, Mr. Chairman. Thank you for recognizing me to speak on second occasion. And I know the hour is late, so I'll try to be as brief as possible. But yes, as the chairman alluded, I did send a letter that the chairman chose to allow in your agenda packet materials. And I wanted to I want to take the committee on a short journey. But in order to do that, the committee needs to be aware of current Georgia law in a different place. This is not a proposal under your colleague's measure. This is already there. Georgia Code Section 16-11-62, paragraph 2, subsections capital B and C, allow a person to have cameras and monitoring equipment in a person's residence. That's already law. That's current law, just like y'all have a camera watching me now. So it just seems to me a little, and perhaps, you know, it's difficult to be the only opposing voice in the room, kind of be the only one that says, well, wait a minute. And I would hope that the committee would also take the posture to just hold tight on this, because despite everyone seemingly being in agreement, I just want to take the committee on a short journey. I believe that the General Assembly in sessions past has referred to a home as a man's castle or a woman's castle, depending on who the resident is or the rightful owner is. And obviously that's your home, your hearth, their home, your place where you have your family, where you've worked hard, all your possessions are kept, a lifetime's worth of work. If someone's in your home or on your land, you have every right to know who's there and why they're there. So under current Georgia law today, Georgia law allows you to put these cameras and monitoring equipment in your home. That's already established law. It's statutory. It's on the books. So just on a short journey, I'm just going to use me to proffer an example in a parallel universe, not saying this would ever happen, but if anybody in this room were to choose to invite me over for dinner and I were to decide for whatever reason to get up from the dinner table and just meander around your home because I'm just curious, I find out that you're placing me under surveillance or monitoring me, I'm going to go, wait a minute. This committee and this General Assembly has passed a law that allows me to aver in an ex parte proceeding without the other that I accuse you of stalking behaviors for placing me under surveillance in your house. Not my house, in your home. So you would be on the hook for a proceeding you don't even know about for something that someone did in your house because that person didn't like the fact that you were aware of what was going on and you allowed the person to be there. I know it seems well and good for everyone to say, well, this seems all agreed to and this seems the right thing to do, but you need to think of the very real world implications, I dare wager, that somebody somewhere might not be doing anything wrong and a person might be perturbed by the mere fact that they learn that they have been monitored. For example, I went to a Super Bowl party at my cousin's residence in Cobb County based on an invitation just yesterday, and they have surveillance equipment at their home. Under this, if I'm perturbed by the fact that they captured images of my person on their land and on their property, I could say, well, I feel bothered by that. I think that they're monitoring me, so I want to secure an ex parte without the other restraining order against them for one of a stalking allegation. Oh, now, wait a minute now. Once you secure that order, it does become a crime. I believe it becomes an aggravated stalking crime, which is a felony. So I just want to, I'm not trying to play devil's advocate. I'm not trying to be mean or spiteful. I hear what your friend and colleague has shared about persons who might be in a dangerous situation. I understand, and I, just like I said in the other bill that I testified to that the chair allowed me to speak to, I understand that there might be a select isolated instance where someone might be able to benefit from this if another person is trying to cause them harm. But I want you to think of how this could be used against you in your house if someone doesn't like it, that you decided to know what they're doing under your roof. And on that, I think that when you look at it that way, I think that you're opening a very large Pandora's jar to allow someone to step forward with a very serious stalking allegation aimed at you if they just don't like it that you just decided to protect your property through monitoring, or even worse, if you had the nerve to ask them, what are you doing going into other rooms or other places in my residence that I didn't give you permission to go into. I think I don't want to be a radicalist or extremist on the examples, but I think it's a very real world possibility under this measure because the matter could be aimed directly at the respondent, which would be the owner of the home. So I would just ask the committee to pump the brakes just a little bit and consider that before everybody just seemingly votes yes to something without considering how it could very well go wrong for someone who hasn't done anything wrong, who might be victimized by another person's false allegation.
You do have some questions, Senator Hatchett.
Thank you, Mr. Weaver. Are there any other hypotheticals that you can think of? Because I understand the concern with someone being able to bring a stalking PTO against you if you recorded them in their residence. But, once you leave, I mean, I'm assuming you were invited there.
Absolutely.
I just don't know if the PTO and the reason for bringing that PTO, if the reason is just because the computers are in that person's home, I don't necessarily think a PTO would be the appropriate method or vehicle to use I guess, to accomplish your goal of he or she stop recording you?
Well, again, the situation that I proffer here, for want of just having robust dialogue with the committee, since you choose to acknowledge me in your question, thank you first for your question, is I understand what you're saying. And again, I was merely giving a hyper example in devil's advocate, but the way the stalking law reads today in Georgia under 16590, one of the elements of the crime is placing a person under surveillance. Under Georgia law today, as I pointed out in my letter, the General Assembly has passed a law that exempts from surveillance the placement of these types of devices in your home under your roof. If you invite me to your house, if this becomes law, if I don't like the fact that you know about what I'm doing under your roof and I feel in any way harmed by this, I could accuse you of stalking, and you go, but wait, you're in my home. That is a protection for you for one of the criminal statute, but it doesn't protect you under the civil liability door that you're opening. And then once that order is secured, any violation by you at your home for one of that order, for one of my presence under your roof, or anyone else's, I'm just using me as an example, could put you on the hook for an aggravated stalking crime, which is a felony, which could be ruinous to your reputation and ruinous to the reputation of anyone else. I'm not trying to be hurtful here. I'm just trying to share the overarching major public policy consideration of if you've worked hard for something your whole life and you have your family or you have your property under your roof, you should know who's on your land or who's in your house at all times. And if anybody is at your house or on your land, they shouldn't have a right of action civilly against you solely for one of you wanting to know who they are, what they're doing there. Because I guarantee you the person who's there probably didn't hand that to you. You had to earn it.
One thing, is that your question?
That's it. Yeah, thank you, Mr. Chairman.
To that point, so the code section 16-590 actually requires not just the surveillance, but for the purpose of harassing and intimidating the person. And that's further defined as a knowing and willful course of conduct directed at a specific person which causes emotional stress by placing such person in reasonable fear for such person's safety or the safety of a member of his or her immediate family, by establishing a pattern of harassing and intimidating behavior and which serves no legitimate purpose. I say that to say, in your example, I would think you'd have to be invited multiple times, you have to have intent, and then you also would have the defense whether there's legitimate purpose. And that may come down to the idea in divorces where you have somebody maybe being surveillanced for a divorce case, and I think that would be a defense that could be raised too. And so while I think you're right on your hypothetical, somebody could, allege anything they want to allege, there would definitely be defenses built in that code section.
Absolutely, Mr. Chairman. And again, I was giving an extreme devil's advocate position of what could potentially go wrong, and even the allegation of it alone. And then the enormity of the allegation, and then you find out that the allegation is vested against behavior that occurred under your roof. I just think that when you're not in a place that you own, I don't think that but the measure of protection for what goes on under your roof, I just think that the committee had robust dialogue amongst the members last year under the previous version of the bill during the previous biennium. And I would just ask again, I'm aware of all the other elements of the statute, but still I want to point out on second occasion that I believe that as a matter of statutory law, I believe I am correct in the reference statute in my letter. So there would be a conflict there because the General Assembly would be speaking out of both sides of its mouth. It'd be saying you can and you can't at the same time, and that would have to be resolved through judicial interpretation. I would just, again, I just want the committee to consider the enormity of it, especially when everything is rooted, again, on third strike, and not for want of being redundant, but occurring at your house, a place where you should be the boss, not someone else.
Mr. Weaver, you got us talking. You got more questions. Don't worry. You get into that debate. Senator Kennedy?
Thank you, Mr. Chairman. Mr. Weaver, thank you. You've raised some really thoughtful questions, and I was having some questions in my mind about this, but you've kind of taken us down a different road from what I was thinking. And I've assumed as I read the statute that it would apply to people and that TPOs could be granted where you have two people occupying the same residence. And you've raised the issue of that's not really in the statute, and it's not. And so you've got the possibility of a visitor coming. I think the chairman points out maybe some limitations on your hypothetical, and I get that. But I'm wondering, would you be more comfortable if there was some element of that would be a part of this, that it have some element of the presumed victim's right to be at the residence? So we're not talking about just a casual visitor. We're talking about someone that has some presumed right to live in the residence.
Thank you first for the question, Senator Kennedy, and thank you also for allowing me to weigh in on that. The public policy considerations and any potential guardrails that this committee wants to place on this measure, or that this body would like to place on the measure in order to ensure that it encompasses a very narrowly tailored purpose to really get at the heart at what Senator Jackson's trying to accomplish, is worthy of extraordinary merit. And I would be appreciative if the committee would have that robust debate and dialogue amongst all of the members here. I just can share with you that, again, based on your acknowledgement of what could potentially go wrong based on the hypothetical situation that I proffer, I just think that you as the father or the head of household, I'm not saying you personally, I'm just saying since every member here, I just think that you should have an absolute right to know, and I think that this opens a very diabolical door for a bad actor to try to potentially use this against someone adversely if those guardrails are not present.
Mr. Chairman, could I ask another follow-up, and it might ask maybe Senator Jackson to weigh in on this, because there's another assumption of mine that that's embedded in my thoughts as I have read this, and that is that a TPO being granted as what would be allowed, I've just assumed that would mean that the victim would be allowed to remain and the respondent likely would be forced to leave the residence. That is sort of the second step of my first assumption, that they're both living there. And I don't know if this is something that Judge Whitaker might want to weigh in on as well. So finding myself, there's a lot that I have baked into my assumptions about how this unfolds. And do you have any thoughts on how once the TPO is granted,
Sure.
What does that practically mean as you envision trying to protect the presumed victim?
That's right. So, Senator Strickland asked this question of, would you still have to go through the process of receiving a TPO? And you would, and in that process, the judge would be able to determine whether or not it was the respondent or the other person who had to move. So it's not guaranteed that the person who is the victim would be able to stay in the house. That would be adjudicated by a judge in that process. So it's not baked in. The outcome, you do have to go through the court system. I think Judge Whitaker can speak more directly to that, but I also want to speak to Mr. Weaver's concerns about the surveillance piece. So he's right. In the state of Georgia, you have the right to put surveillance cameras, anything you want, around your home for the purposes of preventing crime. However, the same statute does require that there has to be a presumption of privacy in spaces that one would expect. So for instance, if you put a camera in your bathroom, I have a right as a citizen who maybe I was even invited into your home, I have a right to expect privacy in the bathroom. And so if you remember the examples I gave, it was often about people invading places where you expect privacy. Women being looked at while they're in the bathroom, women being stalked while they're in the bedroom, where there would be an expectation that you can go in the bedroom and change your clothes in private, right? That you can go in the bedroom and do private things in the bedroom. And so yes, you can put Alexa, you can put cameras all over your home, with the exception of those spaces where we would all presume privacy. None of us, I believe, would go to anyone's house and expect there to be a camera in the bathroom. We expect privacy in that place. And so that's what I'm talking about, is the type of stalking that is absolutely against the law and that would invade people's privacy. It's women not being able to change their clothes in their own bedrooms, not being able to pack up a bag in their bedroom because they have no privacy in their own home.
If I may, Mr. Chairman, nothing in my remarks was tended to suggest that that type of monitoring or surveillance equipment would be installed in the restroom. It's just the bizarre and interesting dichotomy that would exist based on Senator Jackson, your peer and colleagues' acknowledgement of the existence of the statute, for want of places outside of where that privacy expectation vests for one of the public areas, because the bill doesn't, the guardrails aren't there to preclude for one of the non-private spaces. The way I read it is that because of the conflict, if those devices were installed anywhere, someone could say they're surveilling me, not just a place where those devices are in private. But again, the overarching question is, if you've got a home that you've worked for your whole life that no one else gave you, and someone is on or about your property or premise, you should have a right to know who's there and why they're there. And I get what she's saying. I'm sorry, Senator.
No, to be clear, there are guardrails there because the definition of stalking does require intimidation and harassment. So just the presence of an Alexa in your home, I can't bring us, I mean, I could try to get a TPO, but a TPO is not going to be granted to me because I complained that you had an Alexa sitting in the living room surveilling me. But if you show evidence that that Alexa has been placed in a private place, or that Alexa is being used, we've heard testimony before of people using Alexa to start playing really loud music or to really harass people, then that's when we enter into that area of stalking. But there are guardrails already in place in this bill and in the stalking definition.
And my only response to that, if I may, is...
To be acknowledged by the chair.
Oh, I'm sorry. Mr. Chairman, may I please...
Yeah, go ahead.
Just one sentence,
Okay.
acknowledgement. Everything that she said, Senator Jackson said is true, but I would like to point out that the stalking statute itself excuses all of that matter for one of the person's home.
Fair.
So we're circular now. We're the snake chasing its tail.
All right.
So it's just, thank you, Mr. Chairman.
Yeah, from a process standpoint, we're going to go back. Any other questions for Mr. Weaver before he sits down? All right, thank you. Judge Whitaker, were you wanting to testify as well?
Not unless the committee has any questions.
All right, let's see. We have a question from Senator Jones.
Okay. Thank you, Mr. Chair. So I have one for Senator Jackson, a couple actually. The one I kind of want to deal with the example that you were given about the stalking being a private place. But in reality, it still could be like in the bedroom in the real world. Like they've broken up. They don't date anymore.
Right.
And he still keeps cutting on the camera, trying to catch her talking to her new friend, whoever that may be. That can be a form of some type of potential stalk. That's potential domestic violence. I mean, we don't date. We know what the parameters are. For whatever reason, we cannot leave each other. Stop cutting the camera on while I'm on the phone with somebody. I mean, that's real.
That's right.
Okay. And then secondly, aren't we just amending 16-594?
That's correct.
And we're going into the stalking aspect of it, but really in reality what we're doing is 16-594, which is just giving the standing, and the guardrail would be in 16-594 is that you have to file a verified petition, which is under oath, that this has actually occurred, that these events have occurred. So it's not just someone just saying, I think they had a camera on me, I'm going to charge you with stalking. Verified petitions under oath showing that either previous events of stalking have actually happened, and then the court makes that determination. It's really, that's all we're doing here. Is that correct?
Yes, that's correct, Senator Jones. And, we've come before this body before in the criminal code section of 1690, and we've learned from that. We're not there anymore.
Right.
We've come specifically to the TPO section in order to give people standing to get a TPO if the judge deems that it is worth it.
And the judge is going to use the old stalking. We're not creating new stalking. He or she is going to use that stalking statute, whether we like it or not. And that one might work, it may not work, but we're not changing that.
That's correct.
We're just saying that you now have standing to actually go to court.
That's correct.
Okay.
I do have one question, I guess, maybe for Judge Whitaker, since you're here now. So in my day job in the past, I have brought and defended both stalking and family violence TPOs. There was a question raised about property rights. and I don't know if I'm not asking this like I know the answer. I don't know the answer. Under the stalking code section, does a judge have the authority to award any property rights as they would in the family violence section?
Well, they wouldn't be awarding property rights, but they could exclude somebody from a shared property for a certain amount of time. Now, under the hypothetical where the person who is seeking the TPO is a guest in somebody else's home, I cannot imagine, even if they were able to establish all of the elements of stalking that you pointed out, that a judge would exclude the owner from the home. So I don't think that's anything that, realistically speaking, is going to happen. But yes.
So, if somebody is cohabitating with someone, they both have rights, whether under a lease or fee simple ownership to property, and a stalking TPO is issued, then the respondent, if it's issued against the respondent, would, I guess, have to leave the house at that point.
Potentially, not necessarily. I think a judge would look at, if that needs to happen, that they need to be separated, who is more likely to be able to go somewhere else. It's not an automatic, the person who is the respondent leaves.
Right. Okay.
It's more of a stay away, and then you hash out the details.
Right. Did you want to provide any testimony before I open up for any other questions? Any other questions for Judge Whitaker or for Senator Jackson? I would, Senator Hatchett.
Do you see any issues with this? Do you have any issues with this bill?
No, I am fully in support of this bill.
Well, now he's good. All right, what's the pleasure of the committee? We have a motion to pass by Senator Jones. We have a second by Senator Rhett. Any discussion? All those in favor of the motion, please raise your hand. It is unanimous.
Thank you.
Thank you. All right, that's all we have tonight. With that, we're adjourned. Thank you.
10 hours.